Good afternoon, you all. I hope everybody enjoyed the lunch and are awake enough to go through this session, but I promise it is going to be a very interesting session. Honorable Chief Justice of Pakistan, Mr. Justice Umar Ata Bandial, Honorable Judges of the Supreme Court, the Honorable Acting Chief Justice, Federal Shariat Court, the Honorable Chief Justice, Supreme Court of Azad Jammu and Kashmir, Honorable Chief Justices and Judges of the High Courts, the Honorable Chief Justice of the Supreme Appellate Court of Gilgit-Baltistan, Your Excellencies, the ambassadors of various friendly countries who have taken the time out to attend this conference on our invitation, thank you very much. Learned members of the bar, which I see in large numbers, which is very encouraging. Distinguished guests, panelists, ladies and gentlemen, good afternoon. First of all, I would like to congratulate the Conference Committee of the Supreme Court of Pakistan, the Law and Justice Commission of Pakistan, the Secretary of the Commission, and their entire team of youngsters for organizing this wonderful conference. I can see your hard work has paid off. You have done a great job. Well done. The topic for this session of the 9th International Judicial Conference is Economic Challenges and Dispute Settlement Mechanisms, Legislative Response and the Roadmap for the Future. Justice Sandra Day O'Connor of the U.S. Supreme Court wrote as far back as 1980, "The courts of this country should not be places where resolution of disputes begins. They should be places where the disputes end, after alternative methods of dispute resolution have been considered and tried." Disputes are an unavoidable reality of the society and have existed since time immemorial. Disagreements can be unpleasant, even offensive, but they are vital to human reasoning. This is because they generate debate, which is essential to prevent stagnation in the society. Many a progress in civilizations is an outcome of effective resolution of disputes. Understanding disagreement with an open mind gives one a glimpse of the other end of the spectrum. However, excessive and unresolved disputes can harm the smooth working and functionings of the state in the shape of political, social, and economic challenges. It is therefore essential for a country to have an effective dispute resolution mechanism in place. This is especially so because while developed nations have the necessary fiscal muscle to cope with economic challenges, developing nations are only left with options to manage disputes inexpensively and often informally. As such, the importance of alternate dispute resolution, ADR for short, cannot be overstated and is a need of the hour. ADR methods have continuously evolved over the years to meet the ends of modern disputes and provide creative, inexpensive, and expeditious outcomes. ADR is an authentic paradigm shift in the way disputes are handled beyond the traditional court system. A variety of ADR methods exist today which provide effective solution in simple and complex disputes. In an economically tumultuous environment, alternative methods of dispute resolution, such as arbitration, mediation, negotiation, and conciliation, provide business entities and citizens with an option to settle disputes without going through the arduous and expensive process of litigation. In economically challenging times, litigation does not seem to be a viable option, especially to resolve commercial disputes. Businesses must remain afloat so that they can contribute towards the smooth functioning of the economy. Prolonged litigation can prove to be a stumbling block. As such, arbitration and mediation ought to be promoted for effective methods of resolution of commercial disputes. Most commercial entities prefer to resolve disputes by referring them to arbitration. This is primarily because the binding nature of an arbitral award provides certainty to the parties. While it may be tempting to go in depth about how arbitration is carried out internationally, or how an arbitrator is supposed to act in certain situations, I think it would be more prudent to talk about arbitration matters in the context of Pakistan. For instance, how important is the adoption of arbitration as a mechanism for alternate dispute resolution in Pakistan? Is there a sufficiently reasonable legal framework in place that will facilitate arbitration? And most importantly, how would Pakistan's judiciary benefit if arbitration becomes the go-to method for dispute resolution? Historically, ADR has never been a concept alien to Pakistan. Cultural specific methods akin to arbitration, such as referring disputes to jirgas and panchayats, have existed in the subcontinent since time immemorial. While one can argue that there was no parity or party autonomy in the jirga or panchayat, since one could not question the decisions given by jirgas and panchayats, it is nonetheless important to note that there is a history of alternative dispute resolution in Pakistan, which means that it would not be difficult to adopt alternate methodologies for dispute resolution. For arbitration to be effective in commercial disputes, a robust legal framework is necessary. The implementation of an arbitration award is often dependent on the ability of the local courts to recognize the arbitral award in question and whether or not a court has the jurisdiction to implement the arbitration award. In Pakistan, the Lex Loci Arbitri is the Arbitration Act of 1940 and the Recognition and Enforcement Arbitration Agreements and Foreign Arbitral Awards Act 2011. The 2011 Act was legislated by virtue of the fact that Pakistan is a signatory to the 1958 UN Convention on Recognition and Enforcement of Foreign Arbitral Awards, more commonly referred to as the New York Convention. Most foreign arbitral awards that parties seek implementation of in Pakistan come from the ICC Court of Arbitration, the London Court of International Arbitration, the Dubai International Arbitration Center, the Hong Kong Arbitration Center, and the Singapore International Arbitration Center. The process of arbitration is fairly flexible and informal, as we all know. However, the flexibility and informality is lost when the implementation process is regulated as if it was a regular suit and subject to all procedural laws that regulate execution of decrees in our country. This is especially important in light of the fact that in most scenarios, the parties to an international arbitration award use local laws when it comes to the recognition and enforcement of arbitration agreements and arbitral awards, even where the arbitration itself was regulated by another set of rules. Unless Pakistan's laws are brought into the 21st century, it is difficult for the courts in Pakistan to operate in a vacuum. The courts are here to oil the wheels of commerce and not to put a spanner in the works or even grit in the oil. The Supreme Court of Pakistan's recent pronouncement in the case of Orient versus Sui Northern Gas Pipelines Limited, reported as 2021 Supreme Court Monthly Review 1728, has, without a doubt, brought the judicial interpretation of Pakistan into the 21st century, at least in terms of interpretation of the lex loci arbitri. It was held by this court: the jurisdiction of courts under international commercial arbitration is merely supervisory. We deem it necessary to step in under circumstances only where, if we are made aware that the arbitration award or the agreement would lead to unfair outcome for one of the parties. This in no way means that domestic awards would be treated less favorably than foreign awards, but rather the aim to create a level playing field between the two and treat them at par. This interpretation of the Supreme Court has shown that Pakistan has the ingredients required to have a commercially conducive, arbitration-friendly legal framework when it comes to the jurisprudence laid down by the Supreme Court of Pakistan. An arbitration-friendly environment is essentially required in Pakistan to attract and retain foreign direct investment, such as the China-Pakistan Economic Corridor, foreign investment in the power, heavy industry, and infrastructure projects, which attract significant foreign investment. The existence of an arbitration-friendly environment ensures the smooth operation of such ventures. Investors are given the certainty of the fact that arbitration clauses in commercial agreements would be honored and disputes would be resolved expeditiously, which in turn prevents investors from being dissuaded and allows the free market to flourish. ADR, ladies and gentlemen, can be an effective mode also to reduce caseload and backlogs in courts. Presently, there are about 400,000 cases pending in the high courts of Pakistan and around 1 million civil cases pending in civil courts all over Pakistan. ADR would, in my opinion, reduce the current workload on the judicial system. At least it has the potential to do that. In civil cases, mediation and conciliation can prove to be an effective and efficacious remedy in expeditious disposal of disputes. These methods provide parties with privacy and can help parties preserve their relationship. The legal and procedural intricacies which courts are required to follow can sometimes be an obstacle in the way of quick and effective dispute resolution. In sensitive matters, mediation and conciliation offer confidentiality when compared to the conventional court system, where matters become part of public record. Out of cases pending before courts, many are of a personal nature, which do not necessarily require adjudication by a court of law. However, due to a general lack of awareness regarding ADR methods, litigants are forced by default to go to courts. While recognizing the eminent need for ADR, Pakistan has recently introduced various laws. Examples of such legislation, amongst others, are the Khyber Pakhtunkhwa ADR Act 2020, Punjab and Sindh ADR Acts of 2019 respectively, and the Islamabad ADR Act 2017. Under these laws, both civil, and this is important, compoundable criminal offenses can also be referred to ADR. I don't think there are many jurisdictions, criminal matters can also be referred to ADR, but there is this additional feature in our laws that in compoundable offenses, matters can also be referred to ADR. Further, Section 89A of the Civil Procedure Code allows courts in Pakistan to refer matters to arbitration if the litigating parties consent to resolve their disputes through ADR. A way forward for adoption of ADR would be to empower the courts to determine the suitability of whether a matter should be referred to ADR and encourage parties to adopt this route. This would allow the courts to facilitate ADR in suitable matters, but at the same time, not shutting the parties out of the court system should ADR not succeed. The possibility of such eventualities should not overshadow the benefit that the judicial system would derive by adoption and encouragement of ADR. Backlogs of cases would fall, matters would be resolved in months, if not days, drastically reducing both the time and money spent on litigation. The reduction of cases would also allow the courts to hear contentious and complicated matters. The economic benefit that the country would derive from an efficient use of ADR by the judicial system should no doubt be a boon to the legal system as well as the litigants. ADR centers in this context, we would encourage that they be established. Citizen awareness drives must be carried out so that litigants are apprised of the benefits of ADR. Training of mediators, arbitrators, and negotiators must be undertaken so that necessary manpower and expertise is available. Necessary amendments must be made in the laws to ensure that the overriding objective of providing inexpensive justice is met. Colonial laws must be modernized so that they are brought in line with our international obligations to promote ADR. Lastly, the legal fraternity must also play its part in discouraging frivolous claims and encouraging referral of matters to ADR for resolution of relatively simple disputes. Lawyers must play their part in advising parties to settle matters through ADR rather than wasting time and resources on frivolous and long-drawn litigation. Before I conclude, I would like, on a lighter note, to show why one should prefer ADR as opposed to litigation. Fans of Charles Dickens and lawyers alike will, no doubt, be aware of one of his finest works, Bleak House. The central theme of the book revolves around the Jarndyce family and perpetual litigation that embroils the family for generations to come. Dickens wrote, "Jarndyce and Jarndyce drones on. The scarecrow of the suit has, of course, in time become so complicated that no man alive knows what it means. The parties to it understand it the least. Scores of persons have deliriously found themselves made parties in Jarndyce and Jarndyce without knowing how and why. Whole families have inherited legendary hatred with the suit, but Jarndyce and Jarndyce still drags on with its dreary length before the court, perennially hapless." While Dickens wrote Bleak House in 1850s, the message is clear. we have not learned our lessons. To ensure justice between the parties, in my opinion, ADR could be one of the options, and a very viable option. Jaundice and jaundice may be fiction, but with ADR, it will remain fiction, will go back to fiction for times to come. In my view, ADR is, without a doubt, a feasible and effective option that policymakers, lawmakers, the judiciary, and the litigants must encourage, adopt, and promote. I thank you all for attending this conference. We are honored and privileged to have you all. I hope you have enjoyed all sessions. There is one more session to go. And I hope that you will benefit from the thoughts and experiences shared here today and yesterday by eminent and illustrious speakers and panelists in the conference. Thank you very much.